Hi, everybody. Welcome back. Plea bargaining is a peculiarly American institution in the way that it works, and it's worth parsing out the definition carefully so that we all understand exactly what it means. In a plea bargain, the defendant foregoes a trial. The first thing to note is that defendants have the ability in the United States to forego a trial, and they do so by pleading guilty. So although the Constitution, the Sixth Amendment of the Constitution, guarantees every defendant a speedy and public trial, it leaves open the possibility that the defendant, him or herself, may choose not to have that trial for whatever reason. And if a person chooses not to have a trial on the offense with which he or she is charged, they have the option in the United States of pleading guilty. If, at an arraignment where the charges are read to them and they are asked how they plead to the charges, if they plead not guilty, then a trial will ensue. But if they plead guilty, then there is no trial. And a guilty plea entered by a defendant enters a conviction of that defendant by virtue of the plea. It aborts the criminal trial. There won't be a trial. The entire criminal price exaction process, the adjudication part of it, is over with the entry of the guilty plea. The guilty plea is a conviction, but it's not necessarily a confession. If somebody pleads guilty to a crime, it's not taken by the courts as evidence of a confession or testimony by the defendant that he or she actually did that crime. As a matter of fact, it's simply, as it were, an agreement to be subject to whatever penalty follows after the entry of a plea of guilty. Of course, at criminal trials, people have a chance to be acquitted. So there's always the chance, when one elects to plead not guilty and go to a trial, that one will be found not guilty and not have to suffer any punishment at all. But when one pleads guilty to a crime, there is no uncertainty at all. You plead guilty and you've been convicted of that crime, and you are subject to whatever penalty will then be handed down to you. Why would anybody do this? Well, in the plea bargain situation, the vast majority of American defendants do precisely this. They waive their rights to trial and they plead guilty to a crime because they've been promised that they will receive a lesser sentence after the guilty plea than they would be expected to have received after their conviction at trial. So, in a plea bargain, the prosecutor trades sentence leniency for avoidance of the trial, as does the defendant. The defendant gets sentence leniency but gives away the right to trial and therefore the possibility, whether it be slim or not, of being acquitted. That's how a plea bargain looks. It's a trade of the right to trial for a sentencing discount below what one would expect to be sentenced to if one were convicted at trial. The first plea bargain in the United States was recorded in the 1850s when such things were still very rare, and we don't really know how that was actually done. But the practice of plea bargaining became more common after 1880, and by 1930, now America, a fully industrialized, urbanized, and increasingly crime-ridden country, by 1930, the plea bargain was firmly established as the predominant procedure in the American criminal courts to adjudicate guilt and to determine sentences. And since World War II, well over 90% of all American convictions in the federal and state criminal courts are by guilty plea. 90%. And in some urban jurisdictions, it's substantially higher than that. In a place like New York City or Chicago, where there are millions of people and hundreds of thousands of criminal cases, close to 100% of those criminal cases are ultimately resolved with convictions by guilty plea where there's a conviction at all. How does plea bargaining work? Well, in principle, there are two ways that it could work. That is, two ways that the lesser sentence that the prosecutor promises to the defendant can actually be achieved. One is to conduct the bargain between the defendant and the authority who actually imposes the sentence. In the American criminal justice system, that is typically the jury and some in a trial, and sometimes the judge. But it's the judge typically who pronounces sentence at the end of the trial. So if there were to be sentence bargaining, that is to say, if the defendant were to be able to bargain his guilty plea in exchange for a lesser sentence, and there was sentence bargaining, the sentence bargaining would have to be between the defendant and the judge. Indeed, in Britain, as we'll see, something very much like sentence bargaining between defendants and judges goes on, although the judges don't admit it. But in the United States, no such sentence bargaining goes on because judges are not permitted to communicate with defendants or prosecutors in this way, and they're not permitted to make bargains on their sentencing power. Instead, in the United States, prosecutors are given wide discretion to choose precisely the charge that they will bring against a defendant in a criminal trial, and they are asked to exercise that discretion broadly in the interests of justice. In the United States, if a person commits a crime, a serious crime, say an armed robbery, there are so many laws in the United States that a person has probably committed 4 or 5, possibly even more, distinct crimes when he takes a gun, breaks into a liquor store, holds up the store, takes the money from the cash register, and runs out the store. He's committed an armed robbery, he's probably committed a weapons offense, he's probably committed a terrorizing offense against the clerk at the store, and so on. Many, many crimes. The prosecutor retains almost full discretion as to how many of these crimes to charge the defendant with and what the most serious of those charges is going to be. In the situation that I've just hypothesized, the most serious crime is the armed robbery itself. But there are many lesser crimes that are included in the armed robbery, and it's within the power of the prosecutor to decide to prosecute the defendant on some of those lesser charges, or one of those lesser charges, rather than to prosecute the defendant for the armed robbery, which, by hypothesis, most closely describes what it is that the defendant has done. Because the prosecutor has the authority to select the charge with which the defendant will be charged, that is, to select the crime within which the defendant will be charged, then the prosecutor effectively is able to limit the possible sentences that can be imposed upon the defendant. So, as we saw in the state of Connecticut, there are, for example, Class A felonies that have imprisonment for 10 to 25 years as their punishment, and Class B felonies, which can be punished by imprisonment from 1 to 20 years. If an armed robbery, say, is a Class A felony, and an unarmed robbery is a Class B felony, then by charging the defendant with armed robbery, the prosecutor puts that defendant in jeopardy of going to jail for 25 years. But if he reduces the charge to simple robbery, a Class C felony, then the jeopardy of the defendant is limited to the maximum penalty prescribed for a Class C felony. So, whatever the judge might want to do as a sentencing authority, the prosecutor, by selecting the charge over which the trial will be conducted, has the ability to tie the judge's hands and force the judge to sentence within the range that's authorized by the statute. And that's how the plea bargain takes place. It's not a bargain between the defendant and the judge, who ultimately does the sentencing. It's a bargain between the defendant and the prosecutor over what the actual charge that the defendant will plead guilty to is, and depending on what that charge is, it will determine the possible range of sentences that the judge is able to impose upon that defendant. How does all this work? Well, I've given you a hint, but now I'll make that hint explicit. Suppose I've actually committed an armed robbery. I've taken my gun, I've carried it into a liquor store, I've held up the clerk, I've taken the money from the cash register, and I've run out of the store into the hands of a policeman. Suppose I'm arrested and I'm charged with armed robbery, and suppose, hypothetically, the penalty for armed robbery is 20 years in jail. But The prosecutor has hundreds of armed robberies that he has to deal with, and he doesn't have the resources to bring my armed robbery to a full trial. And so he seeks a plea bargain with me. That is, he knows I'm entitled by the Sixth Amendment to have a full-scale criminal trial with all of its rules and all of its uncertainty and all of its costs if I want to have one. And he knows that if I'm convicted at the trial, I could suffer a punishment of up to 20 years for the armed robbery. But I'd like to avoid the trial. I'd like to avoid the expense. I'd like to avoid the uncertainty. I'd like to see this armed robber put in jail for some period of time. So I'll approach the armed robber as the prosecutor, and I'll say, I'll tell you what, you're guilty of an armed robbery. But if you plead guilty to unarmed robbery, then you can't be sentenced to more than 10 years in prison, and perhaps I'll even recommend to the judge that you be sentenced to only 5 years in prison for the armed robbery. Notice that the defendant in this hypothetical case has in fact committed an armed robbery, and so by law, the moral cost compensation that is called for by an armed robbery can be as high as 20 years of imprisonment. But the prosecutor has swallowed the gun in the plea bargain. That is, he's allowed the defendant to plead guilty to unarmed robbery, swallowing the gun, in order for the defendant's consent and agreement to plead guilty to that offense, unarmed robbery, and thereby spare the prosecutor the expense and the uncertainty of the trial. And because the defendant has pleaded guilty to unarmed robbery, there's no chance that he can go to jail for more than 10 years. That's how plea bargaining works. Why is it controversial, as it most certainly is and has been in the United States for decades? The first point, of course, is what I've just suggested. It's the inaccuracy of the outcomes. When the prosecutor swallowed the gun in that hypothetical plea bargain, the defendant pleaded guilty to a crime that was different from the crime that the defendant actually committed. The prosecutor may have his reasons for doing this. That is, he may think it best serves justice by allowing him to internalize more of the ultimate costs of crime by getting more people convicted of something rather than fewer people convicted of something that accurately reflects what they've done. And so the plea bargaining system systematically induces people to plead guilty to crimes which in some cases bear only a faint resemblance to what it is that those people have actually done, and the bias is all in the same direction. That is, in a plea bargain, the defendant pleads to a lesser offense than the one with which he's been charged and which presumably most accurately reflects what the prosecutor thinks he's actually done. So, in a plea bargaining system where almost everybody bargains a guilty plea, then the punishments that almost everybody receives will be significantly lower than they would be if those people had been convicted at trial. And if the trial sentences reflect an accurate estimate of the legislature's view of the moral costs of the crime, then plea bargaining wholesale results in sentences that are far too low to internalize those costs. Nonetheless, the argument is made that the plea bargaining system coerces defendants to waive their right to a trial and plead guilty instead, not by holding a gun to their head and making them plead, but by making the alternative of going to trial so unattractive in comparison with the plea bargain sentence being offered that a defendant who thinks there's any chance that he might be convicted at trial, whether he knows himself to be innocent or not, may find himself thinking that it's a better deal to accept a very sweet plea bargain than it is to go to trial, even if you're innocent, if you think there's a chance that you might be convicted. Moreover, a third point is that plea bargains don't take place in public. The Sixth Amendment guarantees defendants a speedy and public trial, and one of the great virtues of American trials, and indeed a great virtue of public trials everywhere, is that they are public. They're educative as well as devices to impose criminal liability. They make people into citizens by inviting them to observe how the state treats offenders. The state doesn't treat its offenders in secret. It reaches decisions in public on the basis of evidence which is presented in open court and available to the public, and the cases are resolved in full view of the public at a trial. But in a plea bargain, there is no trial, and the sentence and the charge are typically agreed upon in a quick and hushed conversation in a corridor between a prosecuting attorney and a defense attorney. It's done in secret from the public, and frequently it's done out of the hearing of the defendant, him or herself, who's effectively presented in many cases with a bargain between the prosecutor and the defendant's own attorney, and the defendant is under some pressure to accept it so that the prosecutor and the defense attorney can maintain their good relations for future cases. You'll notice that in this lecture, there have been hardly any pictures. Indeed, in this particular lecture, there are no pictures at all, and that's because plea bargaining happens behind closed doors, and there are no pictures of it to be shown. The final objection to plea bargaining is, well, frankly, it's ugly, it's undignified, it's unlovely. As one German authority described it once, it's like justice has become the subject of cow trading. And indeed, there is that aura, that aspect to plea bargaining. There's something majestic about a criminal trial in which the powers of the state are placed in opposition to those of a single citizen, and the state is shown to have to act in a tame way generally. That's dignified, and it speaks to the dignity of the law. But the plea bargain has none of that dignity. It seems quite shabby. Its inaccuracy makes the prices that are determined by plea bargains quite unlike what would be required to actually internalize the costs of crime. And at the end of the day, it looks dirty, and people don't like it very much as a result. Plea bargaining is made possible by two aspects of the American criminal justice system that are not present in the European criminal justice systems that we'll be talking about in a couple of lectures. Plea bargaining is made possible first by the defendant's right to plead guilty and thereby abort the criminal trial. As we'll see, in the systems of continental Europe, defendants don't have the right to stop the criminal trial. They can confess to the crime, but they can't plead guilty and thereby avoid the evidence being presented and a court actually reaching a decision. But in America, defendants do hold the right to plead guilty, and that is a bargaining chip of some value in their dealings with prosecutors. Defendants have the ability to give prosecutors something that prosecutors want, which is the avoidance of the trial in that defendant's case. Plea bargaining is also made possible by the prosecutor's ability to give something of value to the defendant in return for the defendant's guilty plea, and that is created by the prosecutor's discretion to select charges to meet the needs of justice. In my hypothetical example, the prosecutor had the discretion to swallow the gun and to reduce the charge to which the defendant would plead from armed robbery down to robbery so the defendant would get a lesser sentence. If prosecutors don't have this discretion, as they don't in continental Europe, then it's not possible for them to offer the sentencing discount, which is the central feature of the plea bargain and which is what induces defendants to actually plead guilty. That's why plea bargaining is possible. It's necessary because of conditions that aren't limited to the United States and that exist elsewhere, and indeed increasingly so in continental Europe as well. And these are the very, very high caseloads that most American criminal jurisdictions confront. The big cities in the United States are filled with crime relative to those of Western Europe, and this produces enormous strains on the resources of urban police forces and on the resources of urban prosecutors and courts. And therefore, some way to process that huge volume of cases with the limited financial and human resources that the criminal justice system has places immense pressure on the system to resolve cases by guilty plea. And plea bargaining is made necessary by the high cost of trials themselves. Trials are never simple, trials are elaborate, they're nuanced, and they are very, very expensive. So plea bargaining is made necessary by high caseloads and high trial costs, and made possible by the defendant's right to abort the trial with a guilty plea and the prosecutor's discretion to select the charge that the defendant will plead guilty to. And, importantly, plea bargaining is constructed on the assumption that it is appropriate that defendants pay for the costs of actually convicting them, however that conviction is achieved. That is, not only do defendants have to be responsible for bearing the moral costs of their crimes themselves, the plea bargaining system places the costs of convicting them on their side of the account as well. We know this because of the deep sentencing discounts that are offered for guilty pleas. And this is what makes the trial expensive for the defendant. So if a defendant chooses to go to trial, he's in jeopardy of a much higher sentence upon conviction at trial than he would receive at the plea bargain. And as a result, he pays the cost of convicting himself by paying a higher sentence if he has been convicted in an expensive trial. The plea bargain offers him a way to avoid that jeopardy, to avoid that high price by surrendering the right to trial. All of which means that the defendant, in one way or another, either pays for his trial if he's convicted with a higher sentence, or surrenders his right to trial in exchange for the lower sentence. Does plea bargaining impose a price on the right to trial? Well, it depends on two things. It depends on how good a bargain the prosecutor is offering the defendant, and it depends on how likely it is that the defendant would actually be convicted at trial. Let me give you a simple example of how this might work. Suppose that I'm being tried for a crime, the sentence for which, if I'm convicted, is 10 years. So we know that if I'm convicted of this crime at trial, I'll be sentenced to 10 years. But the probability that I'll be found guilty and thus serve the 10-year sentence is 50-50, or a probability of 1/2. Then, as in the problems that we did a little earlier in the course, we can calculate the expected sentence at my trial as the probability that I'll be convicted multiplied by the consequences, the sentence that I'll receive if I am convicted. When I do that, the expected sentence comes out to 5 years. What this means is that if somebody were to offer me a sentence without a trial of 5 years, or the alternative of going to trial, taking a 50% chance of getting a 10-year sentence and a 50% chance of being acquitted and thus serving no sentence, in that case, the value of the offered plea bargain and the expected sentence at the trial are exactly the same. Since the defendant doesn't know whether he's going to be convicted or not, the best that he can do to estimate what's going to happen at the trial is to calculate the expected sentence. And that, in an important sense, is the value that he expects to receive as a sentence in the trial. It doesn't mean he'd be sentenced to 5 years by any trial. He'll either be sentenced to 10 years or nothing. But if he were to have the trial 1,000,000 times, then in half of those trials he'd be convicted, in half of those trials he'd be acquitted. Where he was convicted, he'd get 10 years. Where he was acquitted, he'd get 0. And so, in some important sense, in the average trial, he'll receive a 5-year sentence. If he's offered a plea bargain at 5 years, leaving aside his attitudes toward the riskiness of the trial, the two prospects are more or less worth the same. If the prosecutor offers a plea bargain of less than 5 years, then a price is being put on the trial. Suppose the prosecutor offers the defendant in this circumstance a plea bargain of 3 years in jail. Take the plea bargain of 3 years, or go to trial and face an expected sentence of 5 years. Now, in order to go to trial, the defendant must face a higher expected sentence than the certain sentence that the prosecutor is offering in the plea bargain. And clearly, this does place a price on the right to trial. It's more expensive in terms of expected punishment for the defendant to go to trial than it is to take the plea bargain. And in line with this logic, if the bargain sentence is much less than 5 years, then that bargain puts a very high price on the right to trial. If, in this circumstance, the prosecutor offers me a plea agreement that involves 6 months in jail, then the difference between the 6-month plea bargain sentence and the 5-year expected sentence of the trial is very large. And in order to exercise my right to trial and have my chance at an acquittal, I have to be in jeopardy of a very high punishment relative to the plea bargain itself. And yet, despite its prevalence and its controversial nature, the United States Supreme Court avoided acknowledging the existence of plea bargaining and confronting the constitutional issues that it raised through much of the 20th century. And I believe it might have ignored it down to the present day, except for a case that arose in 1968 that, interestingly, didn't have anything to do with plea bargaining.